Close.
Good morning. The Anne Arundel County Tuesday, July 9th work session will now begin. These meetings are open to the public, but there's no public participation. We have two presentations, and then we'll go through legislation. We're going to begin with Mr. Doug Hollmann, the Administrative Hearing Officer, as he comes forward. Good morning to everyone else, and we'll try and move as quickly as possible.
Good morning, Mr. Persky. Thank you for letting me come and talk to you today. My name is Doug Hollmann. I've been the county's Administrative Hearing Officer for 10 years. I've given you each two packages of materials. The second set is interesting things that we don't have time to discuss this morning that you might want to take a look at later on. The first set of exhibits is going to be copies of what you're going to see up here on the screen. Let me go to the next one. So this is a duplication of what you see on the easel over here. When I came into the office about 10 years ago, I went to the map room and said, can you make me an exhibit that shows the critical area in Anne Arundel County? I did this for two reasons. One was I wanted people to be able to see visually how big, how large the critical area is. It is a 1,000-foot deep swath of property that's subject to special zoning requirements that runs along the more than 500 miles of shoreline that we have. We have more shoreline than almost any other county in Maryland and many, many states. And I thought by doing this, people will go, oh. The second thing is, where have people wanted to live who have moved to Anne Arundel County? In that area that you see there. So that's the reason why that's the first exhibit. The first person to arrive in an area gets to pick where they want to live. For example, take St. Mary's down Duke of Gloucester Street. It's a pretty good piece of property. It rises from the water, and probably they were the first people to move here. The second person to move can't take that property, so takes the next best property and starts what's called infill development, which is still going on to this day. After 10 years in the Administrative Hearing Office, I thought I understood a lot about zoning in Anne Arundel County, and then I ran into something that made me say to myself, wow, maybe I don't understand anything. And that's the next exhibit. This is a bar chart. The bar chart is part of a study conducted by the University of Maryland School of Law and other like Chesapeake Bay Foundation and other entities that studied the critical area variances that were granted in 6 counties around the Bay: Baltimore, Anne Arundel, St. Mary's on the western shore, Kent, Queen Anne's, and Worcester on the eastern shore in a 3-year time period, 2012 to 2014. I was the Administrative Hearing Officer during this time period. I knew nothing about this study. I only found out about this study. It's about 128 pages. It really doesn't arrive at any conclusions that would be worthwhile for you to read it, I think. But on page 32 is this bar chart. And you can see the counties across the bottom, and you can see how many variances, critical area variances only, that Anne Arundel County handled as compared to the other counties. And I looked at this and almost fell out of my chair. I said, what is going on in Anne Arundel County? Are we somehow lax? We don't care about the critical area? We're granting too many? And then I said to myself, whoa, wait a minute. Variances are caused by property owners paying a hefty fee and applying to get a variance from the law. And apparently, people are doing it a lot more in Anne Arundel County than in other counties. So I undertook a journey. Let me see the next one, if you can. These are the 6 counties that are the subject of the study. So if you go back to the previous one, the bar chart, the question becomes, why do we process so many different applications? And I should tell you 2 things about this chart right off the bat. Number one, this is not zoning variances. Zoning came into Anne Arundel County in 1952. The critical area came in 1988. So if you live within 1,000 feet of the water in the critical area and you want to do something and you need a variance, you may need a critical area variance. Maybe you want to do something in steep slopes, and I'm going to give you some examples of that. Or maybe you want to build something that's too close to a lot line, or your property is much too small, et cetera. You may need a zoning variance as well, but this is only critical area variances. The other thing is there are 2 columns for each county, if you notice. The blue one is how many cases were processed. The red one is how many were granted. And I think it's 89% up at the top there were in this 3-year period allowed. And it sounds like a lot, but if you look at the other counties, they're all less. So fewer variances are granted in Anne Arundel County, percentage-wise, than they are in other counties. Now, let me tell you a couple things about what my office does, which handles rezonings, special exceptions, and variances. What is zoning? And one of the reasons I went to the county executive and said, I discovered this interesting diagram, bar chart, and some other things that I think maybe the new county council might be interested in, and it might help you as you go towards comprehensive rezoning. And so zoning is an agreement among property owners in a political jurisdiction, Anne Arundel County in this case, through their elected representatives, which are you, in which the owners of properties in that jurisdiction give up the power to do anything on their property. Remember that before 1952, and you owned a piece of property, you could put anything you wanted on it, and you could put it anywhere on there. In 1952, this network of rules got dropped over your property. So people agreed to zoning in order to give up something, in order to keep other people from doing something, with the idea that overall we will all be better off. And then the county code says that there is a process to revisit zoning every 10 years, but there's a second way to get rezoning, and that is through me. People file an application before me, say I want to rezone a piece of property. Unlike the comprehensive rezoning that you're going to go through, people have to show that either there was a mistake made by the county council when they rezoned it last time, or the neighborhood has changed. They always claim both. I think I've only seen one case where there really was some argument for change, and the others have all been mistakes. One, for example, was a 1-acre piece of land in the middle of the National Business Park that was still residential, even though the whole place around it. It was a slip when they were putting the whole thing together. I don't like doing rezonings. I don't think I have as much information as you do during comprehensive rezoning every 10 years, but there aren't that many. In 2015, we had 13. In 16, we had 9. In 17, we had 11. And last year, in 2018, we had 9 rezoning cases. Again, why is there a second way to get your property rezoned? Probably because it's 10 years in between the comprehensive rezoning. I know there's some thought being given to shortening the comprehensive rezoning time, and then that may make it not even worthwhile to have it still a power of the Office of Administrative Hearings. The other 2 types of cases we have are special exceptions and variances. Special exceptions also, there aren't that many. In 15, we had 23. In 16, we had 25. In 17, we had 23 again. And last year, in 2018, there were 17. A special exception is misnamed. It's not special. It is a special use that the code says we're going to let you have, but you have to meet certain other conditions. For example, self-storage facilities, gas stations, churches, concrete plants, and on and on. How many are there in the code? Over 160 of them. So if somebody comes in before me and they want to put up a self-storage facility and it says it has to be on a certain size type of property and so forth and so on, and they can cross all the T's, dot all the I's, I do not have discretion to deny a special exception because it is allowed under the code if they meet the requirements. This is different from variances. Variances are examples where people want to bend the law. And this is the number of variance cases that we had in those years that you see on the screen at the present time. These include separate cases, but each case can contain multiple requests for variances. For example, there may be 2 or more critical area variances that you might need. You might be in the buffer and need a variance to disturb the buffer, but it also might be steep slopes. But on top of that, you may need to have zoning variances as well. So the fact that those numbers are definitely much higher than what you see there, because the way we've been counting them, we count them as cases. We don't really count them as the individual parts. A variance is a decision by a governmental agency to allow a property owner to use his or her property in a way that is not ordinarily permitted by the code. For example, a property owner who owns a piece of property may want to put a shed in the backyard. The property is small. The shed's supposed to be 7 feet from the side. They want to put it 3 feet from the side. They file an application for a variance. So you may also have situations where people have critical area property variances that they need. And none of these numbers or the charts tell you why people are asking for more variances in Anne Arundel County than they are in the other 4 counties. Let me tell you just a little bit about the history of Maryland and Anne Arundel County. If we can jump past this one. Maryland was the 3rd colony in North America. Virginia was first, Massachusetts was second. This is a map that shows, in a very blurred fashion, your copy is a little bit better, shows Massachusetts, Virginia. Here's how Maryland came about. There was a man named George Calvert. The street outside is not named after him. It's named after his son. George Calvert did good things for James I, who was the Scottish king that came down and took over after Queen Elizabeth died without an heir. James first knighted George for his good service and made him Sir George Calvert. Now, being knighted is only for the life of the person who got knighted. Your son is not knighted, doesn't become sir unless he does something. This is different from earls and barons. James then gave Calvert 2,300 acres in Longmore County, Ireland, that green area in the middle there. And he then made him Baron Baltimore. The name Baltimore comes from a Irish Bailey and Timor, which means town of the big house. That's where Baltimore comes from. So George is now Baron Baltimore. He was also Catholic. And being Catholic was not a good thing to be in England at this time, because the Puritans were on the rise. So he said to James, I want property in the New World. And like the Puritans went to Massachusetts and the people in Virginia. And so did he give them Maryland? Nope, not yet. He gave them land in Newfoundland. And George Calvert got his wife and his kids and his servants, and they went over to Newfoundland, and they spent one winter there. And he realized that everybody had been lying about how the winters were in Newfoundland. So he came back the next year and he said, I want something warmer. James was going to give him what is now North Carolina, but Calvert said, I want to grow tobacco, it won't grow down there. So he gave him Chesapeake Bay, either side from the Atlantic to the Potomac River. The first Baron Baltimore never made it to Maryland, and neither did any of his sons. His son, who became the second Baron Baltimore, there were 6 of them, I'm not going to go through all 6 of them, married a woman named Anne Arundel, spelled with 2 L's. The Arundel or Arundel family was one of the oldest in England, maybe 500 years old. And so Cecil marries Anne Arundel. She was 13 at the time. She gave Cecil 9 children, 3 of whom made it into adulthood before she died at the age of 34. There is no known portrait of her that went out in the hallway as somebody's conception of what they would like her to look like. We don't know too much about her. But the year after she died, in 1650, the third county in Maryland was created, and that was the county that we live in, Anne Arundel. St. Mary's was first. People sailed over to the Potomac River and settled in St. Mary's County, and Kent County came second in 1642. The second set of papers I've given you contains a lot of information about the counties in Maryland, which may be of interest to you. Virginia was not happy that James had given the Chesapeake Bay to Calvert. And there was even a minor war for it. We can have the next exhibit. This is a map that shows the overlaps of claims between Virginia and Maryland, and of course, James then gave land to William Penn, which ended up being Pennsylvania, but that was later. Maryland's form of government was unique. It was not a commonwealth like Massachusetts or Virginia. It was a proprietary province, which means the Calvert family owned the whole thing, lock, stock, and barrel. While we don't have time to go into the history of Maryland, it's interesting to look at a timeline of events. You have 1634, the beginning of Maryland, 1776, the loss of Maryland, and I'm going to get to that, by the Calvert family. 52 is the adoption of zoning. 65 is home rule, which is the current form of government, creating you, the county council, and the county executive, and also the Office of Administrative Hearings. And then in 1988, the state, the county adopt the critical area law. Let me tell you before we leave the Calverts that there were 6 Baron Baltimores, each son succeeding his father. The 6th one, however, died in 1771 without a legitimate heir, so the title Baron Baltimore died with him in 1771, but he did leave behind him a son whose mother he did not marry, so he was illegitimate. That gentleman couldn't inherit the title, but he did inherit everything his father owned, including the province of Maryland. 2 years after he inherited it, there was a new county formed out of eastern Baltimore, and they named it after him, Harford County. So Harford County is named after somebody who was illegitimate. We, having Anne Arundel County, are of course a little bit maybe higher up the rung for whatever that's worth. In any event, Henry Harford, things got worse for him a couple of years later, because then we had the revolution and he lost the entire province. He came back after the revolution was over. He came back and went up the street to the county, to the state capitol, asked the legislature to pay him. He said, "You took something from me without compensating me." They said, "You're right," and they never gave him a shilling. So what happened to Anne Arundel County as far as government is concerned? At the beginning, it was run by the state. Then it was run by a commissioner form of government, which was 5 men who enacted legislation and executed the laws as they were carried out. Apparently, the commissioner system was subject to corruption, at least in Anne Arundel County. In 1964, in a resolution on the ballot, the people of Anne Arundel County voted to replace it with the current form of government, where we have a county council, you, to enact the laws of the county executive on the 4th floor to carry them out. This is known as home rule. The next exhibit is a list of different facts about Anne Arundel County in 1937. I picked 1937 because I couldn't get one for 1951. But this shows you different things about the population. For example, there was 64,000 people. And this goes through a number of other things. The Bay Bridge and zoning both occurred in 1952. Those are the 2 important dates in Anne Arundel County. Let's go to what zoning looked like in 1952. This is what the first zoning of the county looked like. The green area is agriculture. Here's what it looks like now. There's been a lot of development in between those 2 maps. When zoning was enacted in 1952, there was no way to get a variance. The mechanism to grant variances appeared in the 1965 code when the shift was made from the commissioner form of government to our current form of government. The county has a geocortex mapping program where you can look at a property and you can layer it with information. The program allows you to click on a tab that will add a green dot to every property where an application has been filed for a variance. I asked the program to give me all those dots. Now, this is very much like the bar chart in the sense that, wow, there are a lot of variances. And you can see that they're mostly over on the Chesapeake Bay side. So the question then becomes, this doesn't tell us very much except that there have been a lot of variances. Maybe if we look at a smaller area, and what I did was I chose 3 peninsulas on the Severn River. This is 1952 zoning for Sherwood Forest, the Downs, and Epping Forest. Sherwood Forest was subdivided in 1926. Epping was subdivided in 1928. In 1952, the Downs was zoned agriculture. What was the Downs? The Downs at that time was the golf course for Sherwood Forest. There was no development in the Downs as of 1952. Sherwood Forest sold the Downs to developers in the 1980s. Here's a map of current zoning for those 3 peninsulas of land. Notice that the green golf course is now colored yellow and zoned R1 and open space. Did the number of variance cases filed by property owners in Sherwood and Epping differ from the number of variance cases filed by property owners in the Downs? Yes, they did. I asked the geocortex program again to give me the green dots for these 3 communities. And as you can tell at a glance, there were a lot of variance cases in Sherwood and Epping and very few in the Downs. Now, why should this make a difference? Because each of the lots in Sherwood and Epping had been subdivided before 1952. And the size of the lots and the rules for setbacks did not fit what was on the ground. All of those lots, despite the fact that they may not meet the zoning code, continues to this day. They are what we call grandfathered lots. And don't think that Sherwood Forest and Epping Forest are unique. They are not. I chose them as an example because they lay either side of the Downs to show the contrast between properties that were subdivided before 52 and those that were subdivided afterwards. Woodland Beach was subdivided in the 1930s, Cape St. Clair in 1948, and so on. Here's the next thing. This is an aerial photograph of a portion of the Magothy River showing communities with lot lines and steep slopes, typical of communities subdivided before 1952. The red, is it red? Would that be red? Is that Netflix? Red, orange? In any event, those are steep slopes and the lines of tiny lots there. So why did developers subdivide land along our shoreline? Because that's where people wanted to live. And what was going on in the other 5 counties at this point in time? Not much. The Bay Bridge was not built until 1952. Can you give me the next one? Let's see, is the next one? Yeah. The Bay Bridge was not built until 1952. Nobody could get to the other side of the bay to enjoy a waterfront cottage because it took too long to get there for weekends and vacations. Development on the eastern shore did not start until after the bridge was built in 1952. The same is true of St. Mary's County, which was also too far and with poor roads and no railroad access, which is different from our county. Baltimore County has fewer miles of shoreline, and a bunch of that was devoted to industrial uses. Anne Arundel County, on the other hand, was not only easier to get to by roads from Washington and Baltimore, it was served by 2 railroads. One came down General's Highway and in through the mall and all the way down to where the Department of Social Services is now located at the end of Calvert Street. The other one came down the other side of the Severn River, came across the the Severn River, and ended up where the new parking garage for the state is located. If you drive out on Route Boulevard today, you look to the right as you go over College Creek, you could still see the abutment for the railroad bridge that was there. And the next exhibit is an aerial photograph of the Severn River, showing way on the right is the old bridge that was there across at the Naval Academy, and the one up is the Route 50 bridge. And this is very hard to see here on the screen, but your copy should be better. There was a trestle that went across into Wardour, and it was only taken out in the 1980s. And then the railroad line became the Baltimore and Annapolis Trail that runs up through Severna Park. In 1988, the critical area law went into effect. And if you had property within 1,000 feet of the bay, all of those properties right there in that exhibit of the Severn River, were now subject to another layer of zoning. Let's go back to Sherwood Forest, which is a good example of how properties were affected by both the 1952 zoning law and the 1988 critical area law, because it is described as tiny lots on steep slopes. So as a result, it's almost impossible to build anything in Sherwood Forest without variances to both the zoning code and the critical area law. The next example is an application for variances filed this year in 2019. The people wanted to replace an aging cottage with a new house. Here's their site plan. That's what they wanted to build. You can see how small the lot is. This trapezoidal type shape, I guess. They ended up needing a critical area variance to disturb steep slopes and 5 zoning variances because it's too close to all of these areas, and the lot coverage was too much, et cetera, et cetera. The next example is an undeveloped lot on the South River. This is Route 450. Anybody who's driven to Crofton from Parole, you come down and you start driving along the South River, headwaters, and then right down here off the screen, you get to the Dead Man's Curve, where you got to make that turn that just keeps turning and turning and turning. So the South River is this part over here. The red on this are steep slopes. This was a grandfathered lot in a subdivision that was platted before 1988. The owner had the right to build a house on it. The question is where and how large. The owner, his engineers, the county planners, the Critical Area Commission all got together, and they designed a house, this house here, which was not only out of the steep slopes, this is 450 down here in the South River, but it was out of the 25-foot buffer to the top of steep slopes. Now, this pushed it into the back of the lot so that it needed some variances, zoning variances up here. But the critical area law says that if you can help the critical area law by granting zoning variances, do it. So there were some zoning variances granted up here. But you see this little yellow area? It turned out that the only place to build a well was in the 25-foot buffer. And that red line that you see there, this is the 25-foot buffer. Now, this is temporary disturbance, not permanent. The house is permanent disturbance. Temporary disturbance, the truck's going to back in, it's going to drill the well, it's going to drive away, and they're going to revegetate the area. But the critical area law does not make a difference between temporary and permanent disturbance. So a critical area variance was also needed. So in this case, you've got a critical area variance, and you've got a couple of zoning variances. This case is from 2016. It was not included in the University of Maryland School of Law bar chart numbers, but if it had been, it would have been, and anybody looking at the numbers would say, aha, here's the county giving away protection for the critical area, and they would have been wrong. A final example will drive home the difficulty, if you can go to the next one, of dealing with the rights of owners of property that were subdivided before the zoning law and the critical area law came into effect. This is a property on the Severn River. The Severn River is over here to the left. It's a point. The property goes around in here to a cove. These dark areas are steep slopes, and this little tiny red triangle is the only area left for the property owner, even though this is maybe 5 acres or so, to build a home. Obviously, a home could not be built on this property without variances. These cases and many others, and by the way, this guy came in 3 times before we finally got a house that everybody started to agree was small enough to justify variances. These cases and many others show why the Office of Administrative Hearings was established in 1965 to provide a mechanism to adjust the impact of zoning laws on communities subdivided before 1952 and before the critical area law was enacted or came into effect in 1988. Looking at how many variances are requested or how many are granted or denied will not tell you much. You need to look at specific cases to see whether the law is being applied correctly to that specific case. Of course, it is possible to deny all variance requests. Somebody has said to me, why are there variances? The law is the law, isn't it? We should enforce the law. Denying every application would certainly be simple. It's what happened to Henry Harford, who gave the entire province of Maryland to the state of Maryland without receiving a shilling in compensation for the taking of his property. The government may have been able to tell Henry Harford to take a hike in 1783, but they can't do that to a citizen in 2019. If the government takes a part of your property to build a road or widen a road, you get paid. If government regulations deny a property owner the use of his land, he must be paid. Otherwise, he's being asked to donate his property to the good of the bay or the good of those of us who live around it and already have houses. The Office of Administrative Hearings, therefore, attempts to balance the desires of all of us as expressed through zoning and critical area laws with the rights of individual property owners to use the property they own. Let me conclude with 2 things. One is an observation that this is not 1952. This is 2019. A lot of the heavy lifting regarding zoning of Anne Arundel County has already been done. People have decided where the commercial areas should be primarily, the industrial areas, the residential areas, and so forth and so on. So a lot of work has already been done. I can show you the bar chart one more time, but I want to skip past that to show you something. People are going to come to you for, they're going to ask you to rezone different properties for all kinds of different reasons. It has been likened to, in the past, a huge gathering of Arab people on camels and horses in the middle of a desert where they all pitch their tents and then they haggle like crazy for a couple of days until it's all over, and then they go back to their regular lives. People are going to come and ask you about this. I took a photograph of this. I took this photograph. I have no idea who that property is. I don't have any idea as to what changes you should make when you go do comprehensive rezoning. I really don't. You're going to have to look at each one of those individual cases just like I have. The only other thing I can say is that my door is open. If there's ever something you think that I might be able to answer or point you in the right direction, call me. The county code says that nobody's supposed to try to influence me about a pending matter. Pending means there's an application and it's subject to my decision. But if something is not in the pipeline, you can come talk to me about anything. Even if you were thinking, I told the county executive, I said, if you were thinking about asking for a variance on your property, you can come talk to me. There's nothing in the pipeline. The key question is whether anybody tries to influence me. That's what the code says you can't do. And because of some questions from the incoming administration, I've realized that people aren't calling me up because they're worried that I'm going to say, what are you trying to do to me? Well, I just want to make the record straight that if you think I can answer a question, you call me. We're not going to have any problems on that score. So thank you very much, and if I ran over, I apologize. No? Good? Okay.
Thank you, Mr. Hollmann. Councilman Volke?
Thank you, Mr. Chair. Just a quick question, a couple quick questions,
Sure.
Mr. Hollmann. So one of the things that you talked about was mistakes and rezoning applications that come in outside of comprehensive rezoning for you. When you get those requests outside of comprehensive rezoning, do you review the legislative history of the council and anything that was said or put in the record by the council with respect to individual parcels? I guess what I'm trying to get at is what can we put in the record to ensure that people don't think that we just missed something and we just made a mistake? How do we make the record clear that what we did was what we intended to do?
That's a very good question. First of all, there is in the law a presumption, thank you, of correctness. You got a tough uphill fight. When I first got the job, I had a whole bunch of rezoning cases, and I thought, geez, am I just tough, or do I not understand rezoning? Well, they were all trying to see whether the new guy was soft and they could get what they wanted. Basically, that petered away. I've looked at the history, but there usually isn't anything, as far as I can tell. And putting something in for whatever you think it might be worthwhile. For example, not directly on point, when the critical area was passed in the early 1980s, it became effective in different counties. In Anne Arundel County, it was 1988. The judiciary was totally against it. The judiciary is composed of lawyers. Excuse me, Ms. Sherwood and Ms. Hare, and I understand we got a bunch of lawyers on this panel now. And Mr. Volke, that's right.
Ms. Rodvin is too, so.
They were totally, okay. So, okay, yeah, I understand you have a quorum of lawyers. Is that right?
Indeed.
It's a great council.
I was talking to Ms. Hare about it and said I wouldn't hold it against anybody for that. But anyway, the critical area, the judiciary was totally against this. They kept whittling down the critical area protections. The legislature got mad, and they reenacted in 2000, 2004, they tightened things up on it, and they wrote an extensive, almost like endnote to the legislation, calling out the judges, the cases they said didn't get it right, the reason why they didn't get it right. So for somebody like me coming along later, what does this mean? Oh, this is what the legislature said it means. It was like Christmas. So if you want to err on the side of too much, err on the side of too much. If I'm still here, one never knows. And I would certainly be interested in it.
All right, I have a couple more questions. So when you have a request in front of you, and one that I'm thinking about is sort of a special exception request, where there are certain criteria that have to be met, and the code lays out these different things have to be, successfully shown by the applicant to be able to receive the special exception. In the event that you're looking through the code and there's a term that's undefined, where do you go to understand what that term means?
Very interesting and very au courant, if I can switch over to French. I had a hearing last week on the latest medical, what do they call it? Medical cannabis dispensary. Because one of the rules is you got to be, I think, 750 feet away from a public school or a private school. This application, I'm not quite sure where it is in the north end of the county. Oh, yes, I do. It's between Mountain Road and what's the other road that parallels it? When you get out where they're gonna move.
So Magothy Bridge.
Yeah, Magothy Bridge. Okay. So there is a Goddard preschool about 680 feet away from it. So the question became, do they need a variance to the special exception requirements? And in many special exception cases, variances are also asked for. A very easy example is the companies that are now developing gas stations with convenience stores. The code says you have to have a roadway behind for deliveries through the rear. They're not doing that anymore. They want to push the building back. They don't want the road They don't want the loss of space, and so there's always a special exception request plus a variance, because can you please excuse us from this? We don't need it. In the case of the Goddard private school, it's shown that a school is defined as something that's certified by the state of Maryland as a school. And I was given the list of all the schools that were certified by the state of Maryland. Goddard's not in there. Goddard calls itself a school, but it's a preschool. So it's not covered by school. And therefore no variance was needed. And I agree with that position.
I guess to ask you on that, so my understanding of what the code says is that there is a thing called a private academic school, which is defined in code, but then we don't define a public school and we don't define a private school. And in the actual special exception rules, which are present for medical cannabis dispensaries, it doesn't use the term private academic school. It uses the term public or private school. So I guess not just in that situation, but in an overarching way, because we're dealing with this with other legislation where there are questions of should we define terms or not. And I guess my question to you is sort of in a more general sense, if something in legislation is not defined and the code does not define it,
correct,
where do you go to find the definition?
Well, you go outside. In this case is a good example because there is a whole system for saying what is a school and what is not a school. Yeah. And it's the states, not the counties. And now you could trump that. Ooh, I hate to use that word. Excuse me. You could overcome that presumption, right? By saying, by giving your own definition. And I went and looked to see whether it was covered somewhere in the code, and I didn't find it. But if it was in there, and a private school is defined as, then that's the one that would, would bind me. Sure.
Okay. So generally, my understanding, and I just am saying this for the benefit of everyone, you're going to look at the code first for the definition. Absent a definition in the code, you're going to go to common ordinary usage of the word, and you're going to try to figure out what it means. So for a legislative body, it would probably be in our best interest to define as many things as possible. That's what I'm hearing you say.
You can, but it's going to make your legislative counsel work a lot harder.
Well, she's a very hard worker. All right. Thank you very much, Mr. Hollmann.
Mr. Prusky, anything else?
Nope.
Okay. Thank you for letting me come and talk to you.
Thank you so much. Appreciate the presentation and the history. We're going to move along now to Plan 2040 Citizens Advisory Committee General Development Plan. Ms. Elizabeth Rossberg, Chairman.